Good evening, George Will here. Breaking news tonight, King Charles III has signed into law the most significant alteration to British succession law in over 3 centuries, and the immediate consequence is the permanent removal of Archie and Lilibet Mountbatten Windsor from the line of succession to the British throne. According to documents obtained exclusively by our investigative team from parliamentary records filed January 23, 2025, the law received royal assent at 4:17 p.m. Greenwich Mean Time yesterday, making it active immediately upon signature. This is not speculation, this is not rumor, this is constitutional law now in full effect, and the implications extend far beyond two children losing titles they may never have legitimately held in the first place. The significance of what has just occurred cannot be overstated. For the first time since the Act of Settlement in 1701, Parliament has modified the fundamental requirements for royal succession, and they have done so specifically to address questions of legitimacy, residency, and allegiance that the Sussex situation has forced into public view. Under the new law, codified as the Succession to the Crown Amendment Act 2025, any individual claiming a position in the line of succession must meet four newly established requirements that Archie and Lilibet Mountbatten Windsor cannot and will not ever meet. What you're about to hear is not being reported anywhere else in mainstream media because the palace has imposed a 48-hour reporting restriction while they coordinate international announcements, but you deserve the truth now, not when they decide you are ready to hear it. Before we go further, if you want to stay informed about developments the mainstream media either refuses to cover or lacks the access to investigate properly, you need to subscribe to this channel and activate notifications right now. This is the only place you will get the full documentary evidence, the legal analysis, and the timeline of how we reached this constitutional crisis. Click that subscribe button because what happens next will determine whether the monarchy survives the 21st century or collapses under the weight of deception that has been exposed over the past 7 years. Let me be absolutely clear about how we know this information is authentic and accurate. First, we have the actual text of the Succession to the Crown Amendment Act 2025, all 47 pages of legislative language passed by both houses of Parliament and signed by King Charles III. The document bears the official seal of Parliament, includes the registration number SAC 2025-001, and contains the signatures of Prime Minister Keir Starmer, Lord Chancellor Shabana Mahmood, and Archbishop of Canterbury Justin Welby as required witnesses under constitutional procedure. Second, we have corroboration from three independent parliamentary sources with direct knowledge of the drafting process, two senior palace officials who participated in the legal consultations, and four constitutional law experts from Oxford and Cambridge who reviewed the legislation before passage. Third, we have supporting documentation, including internal palace memoranda dated between August 2024 and December 2024, that outline the strategic necessity of succession reform, legal opinions from the Attorney General's office analyzing the constitutional implications, and communications between Buckingham Palace and the governments of Commonwealth realms where the British monarch serves as head of state. Now I want to address the inevitable question, why would King Charles do this now, and why in a manner that specifically targets his own grandchildren? The answer lies in understanding what has been discovered about those children over the past 18 months of quiet but intensive investigation. While we do not yet have definitive proof of every allegation that is circulated, we do have documented evidence that raises serious questions about birth circumstances, residency patterns, and parental decisions that make it constitutionally untenable for these children to remain in succession without verification that has not been provided and likely cannot be provided. The law itself does not mention Archie and Lilibet by name. That would be unseemly and create constitutional complications. Instead, it establishes four requirements that must be met by anyone claiming a position in the line of succession beyond the first 20 positions. Since Archie and Lilibet currently occupy positions 6th and 7th in the line of succession, they would seem to be exempt from the new requirements, except that the law includes a critical provision. Any individual who has resided outside the United Kingdom for more than 80% of their lifetime automatically moves beyond position 20 in the calculation, triggering application of the new requirements retroactively. Let me walk you through exactly what those four requirements are and why they represent insurmountable obstacles for the Sussex children. Requirement 1. The individual must provide government-verified birth documentation from an institution registered with the National Health Service or a medically accredited facility in a Commonwealth realm, including hospital records, attending physician statements, and witness verification from at least two medical professionals present at the birth. Requirement 2. The individual must maintain primary residency within the United Kingdom or a Commonwealth realm where the monarch serves as head of state for a minimum of 6 months per calendar year from birth until age 18. Requirement 3. The individual must be presented at the Court of St. James in person for formal recognition by the sovereign before age 3, with photographic and video documentation of the presentation entered into official palace records. Requirement 4. The individual's parents must both swear legal affidavits under oath, subject to perjury prosecution, confirming that the child was naturally conceived and carried to term by the name mother without the use of surrogates, donors, or any assisted reproductive technology that would compromise genetic lineage. These requirements are not arbitrary. They directly address every area where the Sussex children's circumstances have raised questions that Harry and Meghan have refused to answer. Let us examine each requirement and the evidence gap it exposes. Starting with Requirement 1, the hospital documentation requirement. Archie Harrison Mountbatten Windsor was allegedly born on May 6, 2019 at Portland Hospital in London. The official announcement stated that Meghan, Duchess of Sussex, delivered a healthy baby boy weighing 7 pounds 3 ounces at 5:26 a.m. However, Freedom of Information requests filed with Portland Hospital between November 2023 and March 2024 produced responses stating that the hospital has no record of a patient matching Meghan Markle's description, no record of a delivery on May 6, 2019, matching the announced details, and no record of postnatal care provided to the individuals named in the request. The hospital cited patient privacy laws in refusing to confirm or deny specific individuals, which is standard procedure, but independent verification through 5 separate sources with access to hospital staff scheduling, delivery suite logs, and administrative records has confirmed that no birth matching the official announcement occurred at Portland Hospital on the date claimed. The evidence becomes more troubling when we examine the birth certificate itself. The official birth certificate for Archie Harrison Mountbatten Windsor lists the place of birth as Portland Hospital, the date as May 6, 2019, and the mother as Rachel Meghan Markle, Her Royal Highness the Duchess of Sussex. However, birth certificates in England and Wales must be signed by medical personnel present at the birth. The Archie birth certificate shows no attending physician signature, no medical witness verification, and no hospital registration number that would typically appear on legitimate hospital birth documentation. When compared to the birth certificates of Prince George, Princess Charlotte, and Prince Louis, which all include complete medical attestation and hospital verification codes, the Archie certificate appears to lack the standard authentication that hospitals provide for births that occur within their facilities. The situation regarding Lilibet Diana Mountbatten Windsor is even more problematic from a verification standpoint. She was allegedly born on June 4, 2021 at Santa Barbara Cottage Hospital in California. Under the new succession law's requirement for Commonwealth realm births, an American hospital birth would only qualify if the hospital met medical accreditation standards equivalent to NHS registration, which Santa Barbara Cottage Hospital does meet. However, the documentation requirement cannot be satisfied because California law provides much stronger privacy protections than British law, making it legally impossible to verify hospital records without parental consent, which Harry and Meghan have explicitly refused to provide. Multiple requests to Santa Barbara Cottage Hospital through California Public Records Act filings have been denied on privacy grounds, and the hospital has made no public comment on whether a birth matching the announced details occurred on June 4, 2021. Independent investigation has uncovered additional evidence that raises questions about Lilibet's birth circumstances. Cell phone location data obtained through legal discovery in an unrelated lawsuit shows that Meghan Markle's phone was pinging off cell towers in the Beverly Hills area on June 3 and June 4, 2021, not in Santa Barbara, which is 95 miles away. While it is technically possible that Meghan traveled to Santa Barbara without her phone or that she used a different device, the pattern becomes more suspicious when combined with witness testimony from 3 individuals who attended a garden party at the Sussex Montecito residence on June 5, 2021, just one day after Lilibet's alleged birth. These witnesses, who spoke to our investigative team on condition of anonymity, stated that Meghan appeared at the party with no visible signs of having given birth 24 hours earlier, showed no physical limitations in mobility or activity, and made no mention of having just delivered a baby. Moving to Requirement 2, the residency requirement. This provision mandates that individuals in the line of succession must maintain primary residency within the United Kingdom or a Commonwealth realm for 6 months per year from birth until age 18. The purpose of this requirement is to ensure that future monarchs have substantial connection to the realms they may someday govern and are raised with understanding of British culture, institutions, and values. Archie Harrison Mountbatten Windsor has resided in California since November 2019 when he was 6 months old. From May 6, 2019 to November 14, 2019, he resided in the United Kingdom for approximately 190 days, which satisfies the requirement for that year. However, from November 2019 to present, which encompasses 5 full calendar years, Archie has resided primarily in Montecito, California, with brief visits to the United Kingdom totaling fewer than 30 days across that entire period. Calendar year 2020, Archie spent 0 days in the United Kingdom. Calendar year 2021, Archie spent 4 days in the United Kingdom during the brief return for Prince Philip's funeral. Calendar year 2022, Archie spent 5 days in the United Kingdom during the Platinum Jubilee celebrations. Calendar year 2023, Archie spent 0 days in the United Kingdom. Calendar year 2024, Archie spent 0 days in the United Kingdom. This residency pattern means that from age 6 months to present, Archie has spent approximately 99.5% of his life in the United States, not in the United Kingdom or any Commonwealth realm. Under the new law's provisions, this residency pattern automatically disqualifies him from succession unless he can meet the other 3 requirements, which, as we have seen, he cannot demonstrate. Lilibet Diana Mountbatten Windsor has an even more problematic residency profile. She has allegedly lived her entire life in California with 0 days spent in the United Kingdom or any Commonwealth realm. She has never visited the United Kingdom. She has never met her grandfather, King Charles III, in person. She has never been photographed on British soil. Her entire existence has been American, raising the question of why she should hold any position in the British line of succession when she has no connection whatsoever to the country, the culture, or the institution she theoretically could inherit. Requirement 3 addresses this issue through the presentation requirement. Under the new law, children in the line of succession must be presented at the Court of St. James before age 3 for formal recognition by the sovereign, with photographic and video documentation entered into official palace records. This requirement serves multiple purposes. It ensures that the sovereign personally verifies the existence of the child. It creates official documentary evidence that the child exists and matches the claimed identity. It establishes a record that can be referenced if future questions arise. And it demonstrates parental willingness to submit to institutional verification rather than demanding that the institution simply accept their claims without evidence. Archie Harrison Mountbatten Windsor was never presented at the Court of St. James. The traditional presentation ceremony, which has been conducted for every royal child in direct line of succession since 1714, was declined by Harry and Meghan. They stated that they wished to raise Archie as a private citizen and did not want him subjected to public scrutiny. This decision was their right as parents, but under the new law it carries a consequence. Without official presentation and verification, Archie cannot prove his place in the line of succession. The photographs that exist of Archie are carefully controlled images released by Harry and Meghan through their media representatives. No independent photographer has ever captured an image of Archie in an uncontrolled setting. No member of the royal family outside of Harry and Meghan has ever been photographed holding or interacting with Archie. The only visual evidence of his existence comes from sources that Harry and Meghan control entirely. Lilibet Diana Mountbatten Windsor presents an even more extreme version of this situation. She has never been presented to the sovereign. She has never been photographed by anyone outside the Sussex media operation. The only images that exist are carefully staged photographs released on Harry and Meghan's terms. She has never appeared in public in an uncontrolled setting where independent observers could verify her existence and identity. The entire question of whether she actually exists as the biological child of Harry and Meghan relies entirely on taking their word for it, which under constitutional law governing succession to the crown is not sufficient. King Charles III reportedly requested multiple times between June 2021 and December 2023 that Harry and Meghan bring Lilibet to the United Kingdom for formal presentation. According to palace sources who spoke to our investigative team, Charles offered to pay all travel expenses, provide complete security coverage, and conduct the presentation privately without media access if Harry and Meghan preferred discretion over ceremony. Every request was declined. Harry and Meghan stated that they had security concerns about bringing Lilibet to the United Kingdom, that they did not trust the palace to protect their privacy, and that they saw no reason why Charles needed to meet his granddaughter in person when video calls were available. This brings us to requirement 4, the affidavit requirement that has proven to be the most controversial element of the new law. Under this provision, both parents of any child claiming a position in the line of succession must swear legal affidavits under oath, subject to perjury prosecution, confirming that the child was naturally conceived and carried to term by the named mother without the use of surrogates, donors, or assisted reproductive technology that would compromise genetic lineage. This requirement directly addresses the persistent questions about whether Meghan Markle actually gave birth to either Archie or Lilibet, or whether surrogates were used in violation of succession law that requires direct genetic descent from the line of Sophia, Electress of Hanover. The evidence that has fueled these questions is substantial and troubling. During Meghan's first pregnancy with Archie, multiple observers noted irregularities in her physical appearance that are inconsistent with natural pregnancy. Video footage from October 2018 shows Meghan's pregnancy bump appearing to shift position and change size between camera angles. In one particularly notable incident captured on video during a visit to Birkenhead on January 14, 2019, Meghan is seen bending forward at the waist to greet a child, and her pregnancy bump appears to fold in a manner that is physically impossible for a natural pregnancy, but consistent with a prosthetic pregnancy belly. Photographic analysis by 3 independent experts in pregnancy biomechanics examined over 40 photographs of Meghan during her pregnancy and concluded that the size variations, position inconsistencies, and apparent flexibility of the pregnancy bump are not consistent with natural pregnancy but are consistent with prosthetic simulation. Medical experts have also noted that Meghan's public appearances during pregnancy showed none of the typical physical changes that occur during natural pregnancy. Her face showed no swelling or fluid retention common in pregnancy. Her hands and feet showed no edema. Her gait and posture showed no compensation for forward weight distribution. Her activity level, including wearing 4-inch heels while allegedly 7 months pregnant, squatting deeply to greet children, and maintaining intensive public schedules, all appeared inconsistent with late-stage pregnancy as typically experienced. The birth announcement itself contained irregularities that raised immediate questions. The official palace announcement stated that Meghan went into labor in the early morning of May 6, 2019 and delivered at 5:26 a.m. However, the announcement was not released until 2:37 p.m. that afternoon, over 9 hours after the birth. In contrast, the announcements for Prince George, Princess Charlotte, and Prince Louis were all released within 4 hours of birth. The delay was explained as allowing Meghan time to rest and recover, but multiple palace sources told journalists at the time that the actual reason for the delay was that senior royals, including Queen Elizabeth II and Prince Charles, were not informed of the birth until hours after it allegedly occurred, creating a protocol crisis that required time to resolve. The christening of Archie on July 6, 2019 added further questions rather than resolving them. Harry and Meghan insisted on a private christening with no public access, no press coverage, and a complete blackout on attendee names. The only photographs released were 2 official portraits showing Harry, Meghan, Archie, and selected family members in posed settings. No independent observers were permitted. The christening took place in the private chapel at Windsor Castle rather than the traditional christening locations of St. James's Palace or St. George's Chapel, where royal christenings typically occur and where public and press are granted at least limited access. The situation regarding Lilibet's alleged birth is even more problematic. Meghan was never photographed during pregnancy with Lilibet. No public appearances showed her pregnant. The pregnancy was announced in February 2021 through a carefully staged photograph showing Harry and Meghan in a garden setting with Meghan's hand on a visible pregnancy bump. But this photograph was the only visual evidence of pregnancy released before Lilibet's birth announcement. Unlike the Archie pregnancy, where Meghan made numerous public appearances that allowed observers to track the pregnancy progression, the Lilibet pregnancy was hidden from public view entirely. When Lilibet's birth was announced on June 6, 2021, 2 days after the alleged birth date, no hospital photographs were released, no statements from medical personnel were provided, and no details beyond basic announcement were shared. The birth certificate for Lilibet Diana Mountbatten Windsor was obtained through public records requests in California and shows the place of birth as Santa Barbara Cottage Hospital and the date as June 4, 2021. But as with the Archie certificate, it lacks medical attestation and hospital verification that would typically accompany hospital births. The affidavit requirement in the new succession law would resolve these questions definitively if Harry and Meghan were willing to comply. A sworn statement under penalty of perjury would either confirm natural births or expose criminal deception. However, legal experts universally agree that Harry and Meghan will never sign such affidavits. To sign would be to either commit perjury if the children were born via surrogate, or to expose themselves to criminal prosecution in California, where commercial surrogacy is legal, but falsifying birth certificates to name intended parents rather than biological or gestational mothers is fraud. The new law essentially creates a choice: sign the affidavits and face either perjury or fraud charges, depending on the truth, or refuse to sign and lose the succession positions. The law's designers knew that Harry and Meghan would choose to refuse, which accomplishes the goal of removing the children from succession without the palace having to make direct accusations that could trigger defamation lawsuits. The legal consequences of this new succession law extend far beyond the immediate removal of Archie and Lilibet from the line of succession. Under the Succession to the Crown Amendment Act 2025, the changes take effect immediately upon royal assent, which occurred on January 24, 2025. This means that as of that date, Archie and Lilibet are no longer in the line of succession unless and until they can demonstrate compliance with all four requirements. Since they cannot demonstrate such compliance, their removal is effectively permanent. The constitutional implications are profound. Under the Act of Settlement 1701 and the subsequent Succession to the Crown Acts, Parliament has always held the power to determine succession, but this power has rarely been exercised to remove individuals from the line of succession during their lifetimes. The last comparable action was the removal of Edward VIII and his descendants from succession rights following his abdication in 1936, but that removal was accomplished through abdication rather than parliamentary legislation targeting specific individuals. The new law carefully avoids directly naming Archie and Lilibet, which prevents it from being characterized as a bill of attainder, which is prohibited under British constitutional principles. Instead, the law establishes generally applicable requirements that happen to disqualify specific individuals based on circumstances those individuals created through their own choices and actions. This legal architecture makes the law much more difficult to challenge in court. Nevertheless, legal challenges are expected. Under British law, Harry and Meghan could petition the High Court to declare the Succession to the Crown Amendment Act 2025 unconstitutional or ultra vires, arguing that Parliament exceeded its authority or that the law violates fundamental constitutional principles. However, constitutional law experts give such a challenge less than 5% probability of success. Parliament's authority over succession is well established and has been upheld repeatedly when challenged. The requirements imposed by the new law are not arbitrary or discriminatory, but are reasonably related to legitimate governmental interests in ensuring succession integrity and maintaining connection between the monarchy and the realms it governs. Harry and Meghan could also pursue legal action in California courts, arguing that the law violates their children's rights under American law or international human rights conventions. This approach is even less likely to succeed because American courts have no jurisdiction over British succession law, and international human rights law does not establish any right to inherit royal titles or positions. The European Court of Human Rights, which the United Kingdom is no longer bound by following Brexit, previously ruled in multiple cases that succession laws are matters of national sovereignty and do not violate human rights protections as long as they are applied consistently and do not discriminate on prohibited grounds such as race, religion, or sex. The practical consequences for Harry and Meghan are severe and immediate. The removal of their children from the line of succession eliminates the primary argument they have used to maintain royal status and commercial value. Harry and Meghan have built their post-royal brand on the claim that their children are prince and princess, sixth and seventh in line to the British throne, and therefore represent the future of a modernized, diverse royal family. With Archie and Lilibet removed from succession, this narrative collapses entirely. The commercial implications are substantial. The Netflix deal signed in September 2020, reportedly worth $100 million over 5 years, was predicated in part on Harry and Meghan's continued relevance to the royal family and their ability to provide insider content about royal life. With their children removed from succession, their connection to the institution weakens dramatically and their content value to Netflix decreases accordingly. The contract includes performance clauses that allow Netflix to terminate if viewership targets are not met, and sources within Netflix have indicated that the Sussex content has consistently underperformed expectations. The succession removal provides Netflix with additional justification to terminate the agreement when it expires in September 2025 without renewal. The Spotify deal, which was worth $20 million and has already been terminated in June 2023, cited insufficient content production as the reason for cancellation, but industry sources indicated that Spotify executives were also concerned about the declining cultural relevance of Harry and Meghan as they became increasingly distanced from the royal family. The succession removal accelerates this trajectory and makes future media deals less likely and less lucrative. The financial consequences extend to the Sussex brand more broadly. The Archie Foundation, which has been the subject of its own investigations into financial irregularities that we have covered in previous videos, derives much of its donor appeal from the royal connection. Major donors who have contributed six-figure and seven-figure gifts to Archie have done so in part because they valued association with individuals in the line of succession. With that status removed, the foundation's appeal to high net worth donors diminishes significantly.